But you get on there with life tenure, and you can say what you want then.
Hi, I'm Nick Gillespie with Reason TV, and today we're talking with Reason Senior Editor Damon Root. He's the author of the new book, Overruled, The Long War for Control of the U.S. Supreme Court. Damon, thanks for talking to us.
Thank you.
Your book talks a bit about how there's a kind of libertarian moment happening in U.S. jurisprudence. And your book is actually, in an interesting way, an argument for judicial activism, but of a particular sort. Lay out your case for us.
The libertarian moment that's happening right now is the product of 30 years of academic work, legal activism, lawyers bringing cases, basically arguing that the role of the courts is to protect individual rights and to put a stop to government overreach in various areas: property rights, gun rights. Like the healthcare case in 2012, I mean, right. That was the product of libertarian legal thinking. And what we've seen is...
And the idea behind that was simply that the individual mandate in Obamacare violated, it snapped the Commerce Clause, however elastic you want that to be, saying that the government can compel individuals to do things.
Right, that the Constitution grants the government enumerated powers, and beyond those powers the government cannot go, and that the interpretation the Obama administration was relying on for the healthcare law, for the individual mandate, just exceeded what had been previously allowed and what the Commerce Clause could bear.
In a sense, with judicial activism, the way that we hear about it, it's always, oh, well, judges legislating from the bench, and typically it's conservatives hurling that at liberal politicians or liberal judges. What is specifically libertarian about it, and is that a good thing? Because we always hear, look, we elect legislatures at the state level, we elect Congress at the national level, they're supposed to make rules and courts are supposed to interpret them.
Well, what I tried to do in the book is show that this debate about judicial activism, judicial restraint, it's very old. It's been going on for a century and a half. I begin with the 14th Amendment, 1868, when it's ratified. And at the time, then you had these judges who were considered conservatives. They were striking down progressive and then later New Deal economic regulations for exceeding the government's powers and for violating individual rights.
Can you talk about, give an example of one of the better known cases where in the 19th century or during the New Deal early stages of where the court said, hey, you know what, you can't make this, you can't invalidate this kind of economic activity.
Well, so it's one of the most famous New Deal cases where Franklin Roosevelt loses overwhelmingly 9-0. This was the National Industrial Recovery Act, the NRA, and the court said that this violated the Commerce Clause. Basically, this was central planning. The government was trying to created these what they call codes of fair competition, where they were setting wages, setting prices, telling people what they could produce. Big business and big government were sort of in cahoots, setting these cartels. And the Supreme Court stepped in and said, you can't do this. And this was in some ways the high water mark of the first New Deal, where the New Deal didn't go beyond that in terms of its reach. But then just a couple years later at Supreme Court, there's a change of membership, a change of views, and we start to see this restrained approach to economic regulation. And the New Deal from then on, starting 37, 38, is upheld. And this sort of older view, what would you call the libertarian view, goes out of vogue until 30 years ago.
Another way of talking about this is kind of majoritarianism. If you believe that there aren't particular rights that people have that the government can't abrogate if majority rules, right?
Right.
And liberals and conservatives, many of them are actually on that side. So somebody like Robert Bork, for instance, might say, or would have said, as long as a duly elected legislature voted in a particular law, you got to respect the majority, even if you don't like the outcome.
In his book, The Tempting of America, he wrote, in wide areas of life, majorities are entitled to rule if they wish, simply because they're majorities. And he took sort of a page from Justice Oliver Wendell Holmes, who is this progressive era judge, beloved by the progressives, still beloved by liberals today. And Holmes, in one of his letters, he said, speaking of his role as a judge, he said, if the people want to go to hell, it's not my job to stop them. It's my job to let them go to hell.
Right.
And that's, you just talk about majority rule. That's saying that that the legislative majority is the will of the people that has to be respected, and if we go straight to the devil, then that's fine with them.
Now, part of the question, because libertarians are interested in things like federalism or devolving, certain powers or authorities to competing units of government or subunits of government. Does a kind of thoroughgoing libertarian activism, judicial activism, does it really get rid of the idea of federalism? Does it really say ultimately no jurisdiction can impinge on your individual rights, whether it's a school district or a local municipality or a county or a state or a federal government?
Well, it says that the Bill of Rights apply to all levels of government. And so that the states and the localities can't establish religion, they can't restrict your right to free speech, they can't tell you you have no right to keep and bear arms for self-defense. So in that sense, if we're talking about the federal courts, there's a central federal legal authority that you can appeal to and say my rights are being violated at this local level of government. So I think you could say that there's some tension with federalism there, but at the same time what federalism really says is that the local governments, state governments can do some things, the national government can do others, but then what this approach says, this libertarian legal approach, is that they're all bound by the Constitution, they're all bound by the Bill of Rights, as well as the 14th Amendment, which protects unenumerated rights, unenumerated economic rights, and that the government at all levels has to obey those.
And in a way, I mean, the libertarian judicial thinkers, I mean, what they're doing is saying that the economic aspects of the 14th Amendment, or the implications of that, are as important as kind of the social or civil liberties.
Oh yeah, absolutely. And in fact, one of the big areas of liberal jurisprudence these days, and has been since the mid-60s and early 70s, is privacy rights and abortion rights. And that legal thinking can be traced directly back to these libertarians of the progressive and New Deal era. And in fact, in some of the cases from the mid-60s where the Supreme Court first starts recognizing privacy rights, they cite and anchor that protection in some of the libertarian cases from the 20s and the 30s. So there's a direct sort of connection there, and basically what you see on the legal left is, well, we want the courts to protect these personal rights, but when it comes to economic areas, hands off, total deference to lawmakers.
Is there a clear reason why economic rights, and I mean the courts in general have kind of held them in lower esteem than other types of rights, where does that come from?
That comes from the New Deal. That comes from 1937, 1938, when the Supreme Court stopped protecting those rights, stopped treating them seriously, the same way that other rights have been treated. And that was a long legal battle that was going on. And that's the first half of my book is really about that this decades and decades of progressives, Theodore Roosevelt, Franklin Roosevelt, Woodrow Wilson, all of these leading figures, and then lesser known ones, just arguing that the courts they're intruding on the will of the people, they are usurping democratic process. I mean, basically all the arguments we associate nowadays with conservatives when they're talking about abortion, when they say, well, these liberal judges are legislating from the bench. Well, the progressives of the early 20th century, they were saying that about the conservatives who were striking down.
Because that's when if bakers and bakers and bakery owners say, oh, well, we want to work a lot of hours a week, or that gets invalidated. A law is passed saying you can only work so many hours, and the courts say, no, these guys can contract however they want.
Right, it was called liberty of contract, was the legal doctrine that was found to reside within the 14th Amendment. And that case, the Lochner case, New York had passed this law saying you can't work more than 60 hours a week in a bakery. And the court said, well, that's not a legitimate health regulation. There's nothing about, if you work 61 hours a week, it doesn't make bread unhealthy. There's no scientific evidence to show that this is a health or safety law. And if it's not a legitimate health or safety law, then it violates the 14th Amendment.
Talk a little bit about who are the leading lights of the kind of libertarian legal activism movement, and where did they come from? What are the institutions, and what are their kind of intellectual genealogy? Where does that come out of?
It begins in the academy. It begins with law professors and historians, the late Bernard Segan, Richard Epstein, Randy Barnett. Those are big, important legal thinkers, and their ideas influence lots of people. In terms of putting these ideas into practice, the Cato Institute has a Center for Constitutional Studies. That's been hugely important. They're really kind of at the center of all of this that's going on. In terms of taking these ideas into the courtroom, the Institute for Justice, they're bringing these cases, bringing them to the Supreme Court. Pacific Legal Foundation is doing that also. So you have this convergence of you've got the ideas, you've got these institutions, and then you've got the lawyers and activists who are pushing it in the courts.
And one of the things you hear about always is that the leading law schools, the Harvard, Yales, etc., are always very liberal. Are groups like the Federalist Society or places within law schools that kind of either recognize or started debates about different traditions of law? That's kind of where this all gets started.
Federalist Society is huge. I mean, you can't talk about the fact that we have a Supreme Court right now that is basically right-leaning. There's a 5 conservative, majority on it. I mean, that is the product of Federalist Society activism for many years. Federalist Societies formed in the early 80s on law school campuses. And the conservative legal ideas at that point were really just out in the wilderness, and libertarian ideas even more so the wilderness within the the wilderness. And Federalist Society grows in influence, and liberals, conservatives, libertarians, all of these people participate in Federalist Society events, and these ideas get batted around. Conservative ideas, take hold, and then libertarians start to really influence the conservative movement in a number of areas, and that's, I think, really the fruit we're seeing, right now.
Talk, you mentioned the Supreme Court. We've got, what's the average age on the Supreme Court is like 600 years old.
Right.
What is likely to happen over the next couple of years, and how much does it matter who gets to pick Supreme Court justices? Because this is one of the recurring themes of American politics, particularly presidential elections, that you're not just voting for president, you're voting for the Supreme Court.
Well, it is a huge deal who puts justices on, because they're going to serve for many decades and can have a huge impact depending on the case. I think we're going to see several retirements in the next few years. I think Ginsburg is likely to step down at some point. Scalia, Kennedy, Breyer, they're not far behind. And depending on, if a Scalia is replaced by a Democratic president, that could be a big deal. If Ginsburg is replaced by a Republican, that's a big deal. And that could change the balance on any number of issues.
There's a belief that, at least since Robert Bork and his hearing back in the 80s, that you have to be kind of a non-entity and not really have like a track record or a written record that can be dredged up and actually gone through. Is that legitimate to say about the Supreme Court nominees, or are we getting, are presidents afraid to nominate people who have actually written a lot and done a lot?
I think they are afraid to do that. If you look at Elena Kagan, she was had a very distinguished career in government service, but there was basically no paper trail that could be said. Well, I was the lawyer for the federal government. I was the Solicitor General. I'm not. Those aren't necessarily my views. Those are the views of the administration. I'm just defending them as a good lawyer in court. There was really nothing. Not like Bork. There's just this. This huge paper trail to mine, and he weighs in on everything, and I think that's a shame, because we want these innovative legal minds to be in the running, and instead you've got these very, very strategic people who want to be on the Supreme Court, are like they're laying low, keeping their views to themselves. They clearly have views, they're just not sharing them.
And by the same token, though, there's like no predicting who emerges, right? Like past performance is no indication of future success on the Supreme Court, right? And I guess it was Eisenhower famously said that Earl Warren, who he put on the Supreme Court, was his biggest failure.
Well, David Souter is the one that the Republicans point to, in the recent years where he's put on, and they're expecting he's going to be a solid vote, against Roe v. Wade, and he ends up basically becoming very liberal on the bench. So yeah, there's no real predicting. Some of them are more, maybe safe bets than others, but you get on there with life tenure, and you can say what you want then.
Let's talk a little bit about issues that are either the court has just decided or is likely to in the next term, that are hot. And like, how does your kind of understanding of judicial activism or libertarian activism on the court play out in things like the gay marriage debate?
Well, libertarians have been right at the center of gay rights and gay marriage on the legal front, really for the last several decades. The Cato Institute filed a very important friend of the court brief in Lawrence versus Texas, which was the case that struck down this sodomy ban, this ban on gay behavior in Texas. And libertarians have been pushing for gay rights ever since. And Justice Kennedy, who basically is the swing vote on this issue, who's fairly, you could call him fairly libertarian on gay rights, not on everything. He's susceptible to the libertarian legal arguments, and he cited the Cato brief and his opinion in Lawrence. So I think that those ideas are going to have a big impact on when the court finally tackles.
Yeah, and the court recently chose not to engage in a bunch of lower level courts that upheld gay marriage.
Right.
So,
right.
But you believe that when a lower court strikes down gay marriage, that's when the Supreme Court will take it up.
They're waiting for what they call circuit split, where you have one federal circuit says it states, it's unconstitutional for them to ban gay marriage, and then another one says, no, it's perfectly constitutional. Right. This is traditional lawmaking. This is morals legislation. States have always done this, and once that happens, which there's a good chance it will. There'll be this split, and the Supreme Court will probably take it up then.
Executive power has been, at the forefront of a lot of people's minds and anxieties in the entire 21st century. What's likely to be happening with that as far as the Supreme Court?
Well, there were several big executive power cases last term where the Obama administration lost, basically, 9-0 on a bunch of key issues, recess appointments, the treaty power. And what we're looking at in the future is the NSA spying at some point, that kind of intrusive government overreach that originates with the executive branch or executive agencies, and that's an instance where libertarians are again going to be pushing for limits on the federal government. Their conservative allies on the Supreme Court may depart from them on that.
Yeah, well, talk a little bit about that, because basically, the libertarian argument would be that the state doesn't have this kind of overly broad or unlimited ability to surveil people, even if Congress goes along with it, and it's not fully clear that they have. But conservatives then, who oftentimes will fall in line with libertarians on certain issues, in matters like this, there's kind of a split, right?
Right. I've seen in the Obama years conservatives much more open to the idea that, well, maybe the president doesn't have these really broad, unwritten, unilateral powers, which was a doctrine that was quite popular during the Bush years, because conservatives are worried about Obama suddenly having these powers. Right. The justices on the Supreme Court are a little more insulated from that sort of partisan back and forth, although they may also look at who's in the White House, and that may color their judgment as well. But that's an issue where executive power and police powers, more generally, law enforcement, if you want to call it that, that's something where libertarians are at odds with conservatives in many cases on those issues.
What about the Second Amendment? This is, for decades, there was a real revolution in kind of expanding gun ownership laws at the state level, and now more recently at the federal level, in a way that, if you were talking 50 years ago, I don't think anybody would have predicted that the Supreme Court would be really upholding an individual right to, kind of own and bear arms in a very broad way. Are Second Amendment rights likely to be peeled back anytime soon?
I don't think the Supreme Court's going to be peeling them back. There's a question if the court's going to take another Second Amendment case anytime soon. There have been a number of promising ones. What the court has said is it's an individual right, you've got it within the home for self-defense purposes. Those are the facts of one of the cases, and then that applies to the states through the follow-up case, McDonald v. Chicago. But now there's a question of, well, does the Second Amendment apply outside the home? Can you carry and can you bear the arms in public, and under what circumstances, and what sort of restrictions are allowable and what are not? And eventually the court has to hear that kind of case, because that's something where the circuits are split on that issue.
Is it clear which way? I can understand where the libertarian argument comes down. Is there a sense of where the court would go with a case like that?
It's the logic of Heller and McDonald, the two Second Amendment cases that we've had in the last few years, would suggest that there's some right to bear arms outside of the home, and there may be subject to reasonable restrictions, but it can't be totally banned, and the bans can't be arbitrary and capricious like they are, frankly, in some places. But beyond that, it's not clear. Scalia, interestingly, has made some comments that could be read a few ways. One of which is just like, well, we haven't heard the case yet. We'll decide it when we decide it. And another has suggested that maybe he thinks that, well, the carrying part of it is not so clear cut. But that's something that we're going to have to wait and see. Second Amendment groups are pushing for those cases. Libertarian lawyers who've been truly at the forefront of this from the beginning, Alan Gura, who has basically won these two cases, working with people at the Cato Institute for Justice, Clark Neely, Bob Levy. These guys are libertarian lawyers, and they won these cases, and they're pushing for more.
What about cases about what happens when state law and federal law is in conflict? Most obviously in marijuana cases, and the Raich decision from a few years ago, and a couple of other cases where you have states saying, okay, we're going to allow medical marijuana in the case of Colorado and Washington. We're fully legalizing marijuana for production and consumption. That's at odds with the federal law, and obviously the Obama administration has backed off kind of hard enforcement of that. Is that going to come to a head in the Supreme Court, where we will actually learn, what is the algorithm to say, federal law trumps state laws in certain cases but not in others? Is that likely to come up?
I'd like to see another case like that. I don't think we will. I think the Supreme Court, unless the membership changes dramatically. Scalia cast an important vote on behalf of the federal government, which was exercising what it thought was Commerce Clause powers, so one of the issues in the Obamacare case, and that was an important precedent for the federal government in that case. I think that the court basically says that right now their view is that this issue was settled in the New Deal. The federal government has these broad powers, and they trump the states when the Commerce Clause is invoked. and that you pot smokers, can just go home and cry about it.
Right, or until you elect a federal government that changes everything.
Exactly.
Speaking of Obamacare, there's still a couple of lingering legal challenges. Is that likely to come up again? And if so, is there any reason to believe that the Supreme Court will actually get around to saying, oh yeah, by the way, Obamacare is unconstitutional?
There are four votes on the court right now that say Obamacare was unconstitutional in its entirety, the four dissenters, and it takes 4 votes for the court to hear a case. So I think that there is a chance that one of these tax cases could reach the Supreme Court.
And this has to do with the who collects the tax payments,
right,
or the or the subsidies for various kinds of Obamacare premiums.
Right. The law itself is written in such a way that it seems to say that you can qualify for these tax subsidies if you get it through a health exchange established by a state.
Right.
Now, the federal government has established exchanges that are covering many other states, and
right,
so if you get it through one of these, you qualify for the tax subsidies. And if you don't, then Obamacare kind of falls apart because it loses this funding mechanism. There's a few cases before the federal circuits right now. I think that by the time that kind of issue reaches the Supreme Court, there's a strong textual argument that the law says this one thing, and that's you have to read it. You have to read the law the way it says, and I think there's votes for that. I think that John Roberts had a chance to overturn Obamacare in 2012, and he's probably going to be less likely to do it in 2015, 2016, but you never know.
As a final question, talk a little bit, your work at Reason. I mean, you've been writing for Reason for over a decade. You've been on staff since 2008, and you've always had a strong interest in kind of legal writing and history. Where does that come from?
Just big history nerd growing up in college. One of the things I like about writing about the Supreme Court and about the law is that these are all ghost stories in a way. I mean, there's all of these things from the past that come haunt us in the present, and you need to know all that. And I like digging around and in the old sources. So it's just had a lifelong interest in history, I guess.
All right, well, we'll leave it there. Damon Root, thank you so much. He is the author of the new book, Overruled: The Long War for Control of the U.S. Supreme Court. Damon, thanks so much.
Thank you, Nick.
For Reason TV, I'm Nick Gillespie.